And I'll ask Senator Hatch if you'd like to open us up in a word of prayer. Which mic are you? 11. Make it a long one so everybody will get here.
A good Baptist prayer. All right. Let us pray. Dear Heavenly Father, thank you for today. Thank you for the opportunity to be here. Please continue to guide us to do your will under the gold dome. In Jesus' name I pray. Amen.
Thank you. Once again, if you want to be heard on the bill, please come to the sign-up sheet. There's still one on the podium. We're going to go and collect that. We have 4 bills remaining on the agenda for today. As I mentioned a minute ago, 553 and 371 at the request of the author are coming off for today. We will start with House Bill 497. Chairman of Administration, if you want to come up to the podium.
Sir, I-5 Legislative Council, join me.
Sure.
Thank you.
If y'all want to sit at 2 different ones, so we have 5 and 6. And we are working off LC 338462. Is that correct?
Yes, sir.
All right. The floor is yours.
Well, thank you, Mr. Chairman. I want to begin by congratulating you, Chairman Strickland, on your chairmanship, and thank you for the opportunity to present this bill here today. House Bill 497 is presented to you as introduced. Betsy Howerton with Legislative Council is here with me today. This bill is our annual code revision bill. It adopts the recommendations from the Code Revision Commission, which is working in the off session to make sure that our statutes updated. I was telling some folks earlier, constituents often ask, y'all pass all these bills, why don't you ever take some stuff off the code? And with these bills, we get to make corrections and adopt needed updates that we have in statute. I'll draw your attention to Section 54 in the bill, which is a reflection of the U.S. Supreme Court opinion as it relates to the OCGA and related issues there. So we have some specific updates in that regard, but would appreciate your favorable consideration. And I, along with Betsy, stand ready to answer any questions you might have.
Anything you want to add before we start taking questions?
No, I will say that the Code Revision Commission, one of their primary duties is to, by statute, they're required to have this bill introduced each year, and the Section 54, as Representative Administration pointed out, is sort of the heart of the bill. The rest of it is the commas and that kind of thing. But this is what reenacts the code each year and sort of legitimizes anything that any discrepancies. So, and again, just to kind of piggyback off of what he said, the Supreme Court decision, the Supreme Court relied heavily on this bill that as one of the reasons where they said that Georgia could not copyright the annotations, and basically construed this bill as reenacting and as the General Assembly essentially kind of blessing the case annotations and giving them the force of law. So the provisions of the specific section have been modified to specifically address that and to make, hopefully clear beyond a shadow of a doubt that we do not intend anything except for the statutes to be part of the law.
All right. Any questions for the author or Legislative Council on House Bill 497? There's no one that signed up to be heard. Is there a sign sheet? There's no one that signed up to be heard on this bill. What's the pleasure of the committee?
Move to pass.
We have a motion to pass by Senator Parent. Do we have a second? Second. We have a second by Senator Kennedy. Senator Rhett, correction. Any discussion? All those in favor of the motion, please raise your hand. It passed unanimously.
Thank you, Mr. Chairman.
Thank you so much. Appreciate you. The next bill on the agenda is House Bill 322. And we are working off a substitute that was brought to us. And I have LC 413092S. Is that correct, Representative?
Yes, Mr. Chairman.
All right, the floor is yours. Tell us about this bill.
All right, thank you, Mr. Chairman. House Bill 322, as he said, LC 413092S. It has two parts, excuse me. This bill is being brought to you by the Department of the Child Advocate. Director Davidson's here if we have any questions for her. The first part is simply cleaning up the definition in the Juvenile Code of sexual exploitation. Because prostitution is rendered mute, a child cannot be charged with prostitution. We're merely removing that from the definition of sexual exploitation. Part 2 goes into the creation of an oversight so that people acting as child advocates, we ensure they have proper training so that when they are actually representing these children are actually getting representation they deserve. That is, simply put, the bill.
So as you said in part 1, this is just because a bill, I think it was last year before, decriminalized prostitution for minors. Is that correct?
That is correct.
And so that's simply cleanup language?
That is correct.
And then on part 2, this was not a part of your bill that passed the House. Is that correct?
That is correct.
Was this a separate bill in the House?
It was, and it got hung up, so we've added it on here. Both were requests by the department, and taking this opportunity.
Do you know why it was held up in the House?
I think the workload in juvenile justice was pretty stiff this year, so I think that their hands were full.
And you mentioned the department. That's the Department of the Child
Advocate. Yes, sir. And the director's here if you'd like to hear from her or any questions for her.
Okay. If you want to bring her up as well.
Yep, that'd be great.
How are you?
Good, thank you. How are you?
Good.
Good afternoon, committee. My name is Rachel Davidson. I'm the director of the Office of the Child Advocate. And for those that might not be familiar, our responsibility is to oversee the child welfare system here in Georgia, which of course is broader than DFACS, as well as to provide education and advocacy, ultimately looking to improve the system. And so we, of course, receive a number of complaints, and some of those complaints relate to the quality of legal representation throughout the state for dependency proceedings. And so this bill is an effort to ultimately improve the quality and consistency throughout the state for the legal representation when it comes to dependency proceedings.
Okay. I appreciate it. Any questions from the committee for either Director Davidson or the author of the bill? All right, thank you very much.
Thank you.
There's no one that signed up to be heard on House Bill 322. Is there anything else from the committee on this one? What's the pleasure of the committee? We have a motion to pass by committee substitute by Senator Kennedy, a second by Senator Cowsert. Any discussion? All those in favor of the bill, please raise your hand. It passed unanimously.
Thank you, Mr.
Thank you. Thank you very much. Next bill on the agenda is House Bill 620. Representative Leverett, if you want to come over here. And we are working off LC 413095S. Is that what you have?
Yes, sir, Mr. Chairman, that's correct.
All right, the floor is yours.
Thank you, sir. I just want to thank the chairman and the committee for agreeing to put this on the agenda and to hear this today. This is a bill concerning minor settlements, and as the attorneys are on the committee will know, there is really no such thing as a minor settlement. They're all important. This has to do with settlement of claims of minors. And as you may be familiar, that currently in Georgia law, in order to make sure that smaller settlements aren't consumed by court costs and attorney fees, getting approvals and things of that nature, we already provide that if a settlement is of a certain amount, currently $15,000, no appointment of a conservator is required, no court approval is required, but the parent, the natural guardian, can settle that claim and does not have to go through that process. Acknowledging that over time costs increase and money is not as valuable as it once was, we've increased that amount in this bill. We're proposing to increase that amount to $25,000. So that the parent, the natural guardian, then would be able to settle a claim of that amount or less and wouldn't have to go through all those legal hoops, for lack of a better word. Additionally, we're making other sections of the code that deal with minor claims and settlement of those claims consistent in that we're increasing the amount. And then we're also trying to clarify some existing provisions of Georgia law that govern approval where those amounts are higher. If the amount goes above $25,000, some sort of court approval has to be obtained, and in some cases a conservator appointed and probate court approval obtained. And when there's a current case pending, it's sometimes confusing under Georgia law what court you have to go to get the approval, and this seeks to clarify all that. One other issue it addresses is with bonds. The bond requirement is not removed, but it is clarified that if the only asset of the minor is that claim, you don't have to obtain the bond until you've settled the case, so that you know what the amount of the property is of the claim is, so you can set the amount of the bond, because obviously you can't just buy a bond in an indeterminate amount. It has to be a specific amount. So we, should add, this is a collaborative effort of the fiduciary law section, the probate judges, the state court judges, and I also understand this has the approval of Professor Radford, which I'm led to believe is the equivalent of a grade A rating in the agricultural industry. So hopefully that will make the committee feel more comfortable about the quality of the work here.
And we have a substitute in front of us. What's different about this versus the version that passes in the House?
There are 5 basic differences, Mr. Chairman. The version that passed the House, and I would say those differences are not necessarily substantive. They were just viewed by primarily the fiduciary law section as needing some clarification. So the first change is under the current sub is on page 6 on lines 138 and 139. Those 2 lines were added. So we're adding section 4 of that code section, and the underlying language is being added there. The second change was, well, it would be on the next page. There was a change to code section 29340 that added a sentence, and that section has been removed, but the same concept appears a little later in the bill in lines 175 through 183. The third change occurs on the next page of the substitute, which is page 8, and section D there. The section has been revised in that conceptually there was some additional elaboration on the concept that whether the asset is only one or more choices of action, that is claims, the bond isn't required until the value is determined. And then if a conservator has already been appointed without a bond, then they have to go back and get a bond before they can receive the proceeds of the settlement. The fourth change, Mr. Chairman, was, well, on page 10, it's no longer there, but there was a proposal to add some language, again, saying that the administrator or conservator had no authority to receive the settlement until they had posted a bond. And we've effectively included that concept in other portions of the bill, and also at the very end on page 11 there. And that was changed. There was an addition to section E of that code section. This is lines 261 through 279. But we've just simply, again, kind of elaborated on the addition to make it a little clearer, hopefully.
All right, thank you. Any questions for the author? Senator Calzert.
Yeah. Thank you, Mr. Chairman. Representative Leverett, I think I follow your thought process with this, but I'm kind of curious as to why are we raising the amount of money that, a person can settle a minor's claim without being held accountable?
Well, I acknowledge the concern. I think the view is that we are allowing the settlement to be affected by a parent or a next friend here. That is another addition, but we're not allowing the next friend to receive the money unless they become a conservator. Only the parent can receive the money. And so I think there's 2 issues there. One is that there's a feeling that over time the costs of the money doesn't go as far as it used to, so we're really just updating that amount for inflation. And 2, we still have it controlled because it has to be a parent of the child that can actually receive the money without a bond or a conservator. Anybody else has to get a bond and become a conservator to receive the money.
The reason for being appointed a conservator posting a bond is to make sure that that child receives the money when they turn 21 years old, right, or 18?
Yes, sir, that's correct.
Well, that worries me that, you know, the child is no longer protected now unless the settlement is over $25,000. So basically, somebody can abscond with up to $25,000 without any court supervision or, you know, returns due or bond to guarantee they don't spend the money.
Well, that's true. I suppose I would say right now they can do it up to 15.
Right.
And I think, at least in my view, because you're only allowing the parent to receive the money, there's a greater assurance that the money would not be dissipated for the benefit of the child.
Is that a change to only let the parent take the money? I mean,
I don't believe so. I believe
yeah,
that
so
was.
right now the parent can take the money up to $15,000, but if the child is entitled to greater than $15,000, they're given these protections.
Yes, sir.
So we're weakening those protections for a minor child in this legislation.
Well, I would say that I suppose, yes, in a sense, that's correct. But because 15,000 doesn't go as far as it used to, we're just updating that amount to reflect to adjust it for inflation, I suppose I would say.
Okay.
On that same note, there are other legal obligations that any parent or whoever it is that's receiving a settlement for a minor has, no matter what the amount is. Are there other legal obligations, fiduciary obligations that they have by law elsewhere?
I mean, it's my understanding. I could not list them for you, Mr. Chairman, but that is my understanding, yes, sir.
Okay. Any other questions for the author? We have a couple other people that signed up to speak on the bill. They might can answer some of these questions from Senator Cowser as well. Bob Bray, with the Executive Director of the Council of State Court Judges. Now, also note in your folder, there's a letter from Judge Sapp. He may mention as well, Chatham County State Court, concerning this bill.
If I may. Good afternoon. Thank you, Chairman Strickland and members of the committee. My name is Bob Bray. I'm the Executive Director for the Council of State Court Judges. We're delighted to be here to offer our support for the bill. This is something that Judge Sapp, Greg Sapp is the Chief Judge of Chatham County State Court, brought to our attention a couple years ago. There seemed to be some confusion dealing with gross settlement and not really defining what net settlement was. And so we had worked with the probate judges and the State Bar and GTLA and others, and they have taken the ball and done good work with this, and we feel that this wording does accomplish what Judge Sapp was trying to achieve with this. I think to answer Senator Cowser's question, from what Judge Sapp just sent me, was that this $15,000 number was established a long time ago, and it's been $15,000 forever, but that the rate, the insurance rates have raised to $25,000, so that's why they were bringing it up to the $25,000 number. But we are here to support the bill.
Any questions for Mr. Bray? All right, thank you very much. We also have Adam Malone with the Georgia Trial Lawyers Association.
Thank you, Chairman Strickland and distinguished members of the committee. I'm Adam Malone. I am here on behalf of the Georgia Trial Lawyers Association and as a practicing lawyer that frequently represents minor children to speak in favor of the bill and here to answer any questions. As has already been pointed out, this has been a great collaborative effort on the part of the fiduciary law section, probate judges, state court judges, and the Judicial Council, with some input from us. And we're very proud of the work. We think it streamlines the process of settlement of claims for minors. It saves money, eliminates waste, and it also provides clarification in otherwise confusing areas about which court to go to, whether the case is pending or whether it's a pre-suit settlement, and it clarifies all that and will have us going to the right court every time instead of sometimes showing up in the wrong place. I'm here to answer any questions you might have. I don't think there's any controversy among those who are interested in producing this legislation, and thank you to Representative Leverett for getting it through the House. But I'd be delighted to answer any questions that you have or concerns that you have about the bill.
I have one question, the same thing I was asking earlier. So right now, going back what Senator Cowser said, if in a current law, we're raising this to $25,000, if the amount is $15,000 or less, can the parents just take that for their own use, or they still have to hold that money for the minor with any other fiduciary obligations that come in by law?
Well, they would be expected to hold it for the benefit of their child. It's their child's money, but they're trusted to hold it as the loving parent. And of course, parents have a legal duty under Georgia law to provide for the health, education, maintenance, and support of their children out of their own funds, so they wouldn't be authorized to use that money for those purposes. And I suppose when the child turned 18, if he found out that the parent ran away with their money, that they might have a lawsuit that they could bring against the parents.
Now, I guess to answer my own question, that's existing code on lines 21 through 23 in the bill, dealing with the right a natural guardian would have to hold the personal property for the benefit of the minor. And so we're just raising the limit on the minimum amount, I guess you'd say, when you have to have a conservator appointed then.
Yes, Mr. Chairman, and it goes further and says, and shall be accountable for the personal property.
Yeah. We have a question from Senator Hatchett.
Yeah, I just have one quick question. If this bill has a retroactive effect, if a settlement between $15,000 and $25,000 was made, in the past, the child hasn't turned 18 or 25 yet, or 18 or 21, whichever the settlement would allow, does it have a retroactive effect?
Well, I'm just reading in the preamble to provide an effective date, and I don't know the answer to your question, but I think that it is effective. Section 9, it is effective upon approval by the governor, and it's becoming law, or it's becoming law without such approval. So I believe it's the law as of the date that it's signed.
Okay, thank you.
Any other questions from the committee? Senator Cowser?
Explain what you meant by the choice of courts.
Okay.
It simplifies that for you somehow.
Thank you, Senator Cowser. So if you're handling a claim on behalf of a minor and you reach a settlement with the other side and lawsuit is not filed, it's very clear now the court with exclusive jurisdiction to approve that settlement would be the probate court. If the lawsuit has been filed and you reach a settlement, the wording in the code as it exists right now, it says submit it to the court. And then there are other provisions that talk about the court in which the action is pending. And so I personally have had the situation where, well, let me answer it this way. If the case is pending, there's no question that the trial court must approve the settlement. The question is, do you then have to go back to the probate court for a second approval? I've had some probate judges fuss at me because I didn't come back. I've had other probate judges, when I did come back, say, what are you doing here? You've already had this done. Why are you taking up my time? So this bill eliminates that confusion and provides very clear direction that you only have to get approval from the trial court if the case is pending.
Okay. And that's current law that if it's a greater than $15,000 settlement and there's a lawsuit involved, the trial court has to approve that settlement to protect the interests of that minor child.
That's correct.
So we're abandoning that on any case below $25,000.
Let me go back and there's more of an answer to your first question.
Okay.
So if the claim is settled for more than $25,000 in a pending case, the trial court under this substitute bill has exclusive jurisdiction to approve the settlement, but only the conservator can compromise the claim because the claim is worth more than $25,000. So you would still have some probate court oversight in these claims over $25,000. It's just the approval has to come from the trial court.
Right. But you no longer would have even any kind of conservator overseeing the thing or any court intervention in approving a settlement if it's less than $25,000.
No conservator is required if it's the natural guardian, if it's less than $25,000.
Okay.
That's correct.
And can you do it, we got some non-lawyers on our panel here. Can you explain what's required to get court approval or to set that up? I mean, in my experience, that's not particularly complex to do. It's kind of routine, but will you tell them what you have to do to get that?
Yes, sir. So, well, you first have to get the other side to agree to a settlement. That's
the
a
hard
monumental
part.
task in and of itself. And once you have accomplished that, then you prepare a motion for approval, and you prepare the list of expenses that were necessary to expend to produce the settlement, attorney's fees, whether there are any liens that have to be repaid out of the settlement proceeds. And then the trial court must review it and can hold a hearing and take evidence to determine whether the fees, the expenses, and the liens are valid and whether they're all reasonable and in the best interest of the minor. You know, there are some settlements which are rather straightforward and rather simple. There are others which are far more complex, especially if you have multiple health insurers or others who have paid medical expenses claiming a right to be reimbursed, and some of them have that right, some of them don't have that right, and you know, quite complex hearings sometimes have to take place. And at that stage of the game, the trial court, who has presided over the entire litigation, is far more familiar, at least, with what it took to produce the settlement, what the evidence was, whether the compromise was fair in light of the risk of going to trial, than perhaps a probate court would be, who did not preside over all of that.
Senator Watson.
How long has it been 15,000?
I wish I could tell you, but I've been practicing law for 20 years, and it's been that for that length of time, and I believe it was that for at least that long prior to that time.
Oh, wow.
Just because my law partner, who's now deceased, you know, had me believe in that, and
So-
he had practiced for 50 years.
Woo. Okay. So it's been a while. Okay.
Any other questions from the committee? Thank you very much.
Thank you. Appreciate being here.
There's
Thank
no
you for
one
your
else
work.
that's signed to be heard on the bill. What's the pleasure of the committee? Motion do pass by Senator Watson. You trying to suck up to your judge? That's fair. Second by Senator Parent. I know he's watching. He'll remember that, I'm sure, if you go in front of him in state court. Any discussion? All those in favor of the motion, please raise your hand. 1, 2, 3, 4, 6. Any opposed?
I'm just going to abstain.
Abstain.
But my good friend, Representative Leverett, and I know he has good intentions.
Fair enough. Concurring opinion, right? Is that what that is? 6-0, the motion carries. Let me go back. I didn't do this earlier. Who's going to carry the bill in the Senate? Senator Calzert?
Yeah, I was going to
I was afraid he's going to say my name, so I said yours first.
Well, I had heard that the Judiciary Chairman was anxious to carry this, but I may be mistaken on that.
Yeah.
We actually don't have a sponsor.
You wanna- All right. All right. Thank you very much. Senator Calzert will carry it. We'll see what it looks like. We'll see what it looks like when it comes to us. All right. Next bill on the agenda is House Bill 112. Don't sweat it too much yet. Senator, Mr. Whip, actually. Whip Kelly, how are you? Are you going to sit right there?
Chairman.
That's fine.
Thank you, Mr. Chairman.
We have LC 338502, is that correct?
That's it, Mr. Chairman.
All right.
It's always great to be here with you, and congratulations. I'll echo the words of Chairman Efstration. Congratulations on your chairmanship, and excited to see the work always excited to see the work that this committee does. So it's great to be before y'all today. I come before you with House Bill 112. It's LC number 338502. What it simply does is changes the sunset on our COVID liability statute from July 14, 2021 to July 14, 2022. That's, as you'll remember, that's the measure that we passed of June of this last year when we came back for our to finish our session. It was originally Senate Bill 359.
And just so everybody knows, in our folders, we actually had the version of Senate Bill 359, so you could see it as we passed last year. Yeah, it's in the back of your folder. Questions from the committee? You still have a question, Senator Parent?
I do, yes. Thank you, Mr. Chairman. Thank you, Representative Kelly. Question, so I voted for this last year.
Thank you.
Because I felt on balance with everything that was going on and all the consternation and obviously the newness and fear really about COVID, that it was a fair measure. I'm a little less convinced that it needs to be extended. So my question is, what public purpose is really served now by letting negligence off the hook? Like back when we weren't sure, when everything was so confusing and no one had masks and the procedures weren't, I mean, we're way down the line from that now. We're about to all be vaccinated. So why is it good to encourage negligence at this? I don't even think there have been lots of lawsuits.
No, there hasn't. I think.
And let me correct. I shouldn't say encourage negligence, but sort of allow it.
Well, I don't think we're simply just allowing it by the statute. I think what we're trying to do is help our business community feel comfortable opening up and staying open. And that was something that was important when we did it last year, trying to get our economy going again. We know that it took a dip during the 3 months in between when we adjourned session and came back in June, and we were trying to give the business community some certainty so that they could stay open, so that we could keep our economy on track. And fortunately, we've been able to do that. I don't think that as we continue to learn about COVID, our small business owners need to know that they can be open without just fear of maybe missing one or two things and opening themselves up to a lawsuit. I think right now we need that certainty, and that's why I think we need to continue to extend it even during the hopefully we'll all be getting vaccinated, and hopefully we are turning the corner on this. But I do think it's important while this goes on, and do we have it for at least another year, and that's why I've simply asked for a 1-year sunset.
Can I ask a couple of follow-up questions? So have there been lawsuits related to people saying I contracted COVID? No? I'm
not aware of that. And I think one reason because of that is because of the statute that we put together very thoughtfully and with a lot of input to where there was conduct that was unacceptable to us public policy-wise in Georgia, that they could be held accountable. But in areas where our business owners and medical workers and are those on the front line of this pandemic are acting responsibly, that they're not dragged into court because of that.
Okay. Last question. Have you heard from businesses that they're planning to close if we don't extend this?
I haven't heard from businesses specifically telling me that they would close. I know I've had a lot of business owners contact me and tell me thank you for doing this, because it gave them the certainty to open. Okay. And I do believe you will hear members of the business community say that they would be in fear of staying open should they not have this legal protection.
Well, I guess I find that a little questionable, but thank you.
Well, these are crazy times.
Appreciate it.
I appreciate the questions. Thank you.
Senator Rhett.
Thank you, Mr. Chairman, and welcome, Mr. Whip. I was just curious as to why.
Always good to be with my friend from Cobb County.
Thank you. Why did you choose a year instead of 6 months? Is there any?
Because doing it 6 months from where it would put us right at the beginning of session next year. What I've kind of looked at is I wanted to give us this year so that we would have an opportunity to come back as a legislature here next January through March and address it again if we need to, or simply let it expire at that time. But doing it 6 months, I was concerned that there would be a gap period in between when we could get legislation across the finish line, and felt the year was a little more appropriate for that. Thank you.
Dr. Watson.
Thank you, Representative Kelly. Sure appreciate you bringing this and regapping this. I will tell you, two issues. One is that we're not all going to be vaccinated. That's we all understand that. So to say that is not dealing in reality, unfortunately. Now, personally, I think we all should be vaccinated. That's my thoughts, but I practice medicine. And I will tell you, the businesses, including healthcare providers and the practice that I am, is very appreciative of this piece of legislation, and just want to applaud you for re-upping and thank you so much. I mean, it's the unfortunate fact that yes, the cases are going down. They're still too high right now. We're all getting, a lot of us are all getting, we hope we all get vaccinated. But the fact is, we're probably going to be having cases of COVID a year from now too. So that's the tough part. So, which leads up to my mask bill that's in the House, and I appreciate any consideration you could have there.
Well, Senator, I want to thank you for what you've done, and I do think this is an important piece of legislation. But the work that you and the medical community have done over this last year, I mean, we're almost here at the year anniversary, and I couldn't be more grateful for those of y'all who have been on the front lines and have been treating sick patients, both from COVID and outside of that. And the work y'all have done has been tremendous. It's one of those things in such turbulent times, it's hard to see the good sometimes, but what y'all have done is, hope for all of us.
Thank you. It is teamwork.
On that same note, I think I'd share what Senator Watson said. I mean, we've gone almost a year with this, and all you're doing is making it go one more year. I think even though we hopefully are getting close to moving past COVID, we learned a lot about the virus in the last year. There's still a lot we don't know, and what we do know is because of the leadership in our state, Georgia continues to outperform most of our states in the country as far as reopening and keeping our economy going, which directly affects our ability to appropriate funds for our most vulnerable in our state. And so I like that you're just simply changing the date and not trying to redo this whole thing on the fly here 1 year in. I think this is the right move for one more year. On that note, the opposition I sometimes hear on this is that this will impact workers and possibly claims that workers would have. Can you just briefly address how any claims that a worker would have are impacted by this law?
Thank you for that, Mr. Chairman. We were very careful in drafting this statute, and we made clear on line 157 of the original bill that this in no way, this chapter shall not modify or supersede the terms or application of Chapter 9 of Title 34 relating to workers' compensation. And traditionally, any transmission cases of any virus or disease would go through the workers' compensation system. And so this makes clear that this has no impact on that.
Okay. Thank you for that. Any other questions for the majority whip of the House? Senator Calzert.
Thank you, Mr. Chairman. I've had problems with your bill for a while because of the definitions of gross negligence and ordinary negligence. Can you explain to the committee what is meant by gross negligence?
As you know, Senator, we typically tort claims under Georgia law are brought with just a negligence statute, and when we move up to gross negligence, that's terms that the court through common law and court rulings have said is a much higher standard of negligence, and we felt like that was important, that we did move away from just simple negligence and giving the increase of the gross negligence.
You agree that the legal definition is ordinary negligence is the failure to act with the ordinary care in similar circumstances, whereas gross negligence is just the failure to exercise slight care under the circumstances. I mean, you're defining that as a much higher standard, but it's really pretty fine line there, isn't it?
I feel like it, when the court interprets gross negligence, the way that they give it is sufficient here. I know me and you had a pretty thorough debate about this back in June, but I do continue to feel that gross negligence is an appropriate standard.
And if I continue, my second major concern with this bill is that it's just so deceptive to both the public and to the business community that they're actually protected by this warning. The line 123 goes into the individual or entity of the premises. If you post there at the point of entry the warning sign, and the warning says there is no liability for an injury or death of an individual entering these premises if such injury or death results from the inherent risk of contracting COVID-19, you're assuming this risk. But in reality, you're not waiving a claim for anything other than ordinary negligence, because all the others are disclaimed. And if a business thinks they're protected against slight negligence, they're not. And the public, your own bill says, you know, they're not excused or you know, waiving any claim for anything other than just ordinary negligence. Why wouldn't you be fair in that statement like you were, you know, right above it there at line 118? If it's on the proof of the receipt or your ticket to a ball game or whatever, you can make it clear to them you ain't waiving any of this stuff. But then you put the signs on the door that make it sound like people walking in there are waiving, you know, any kind of claims, and the businesses are sitting there putting these signs up assuming they're never going to get sued when they are going to get sued for gross negligence, right?
They could be still held for gross negligence, but I'll tell you, Senator, the intent was never to be deceptive, certainly not at all. That was language that we crafted specifically from the business community with their input, and that was the language they felt they needed. And I am proud to, when we pass out of the House, to have had the support of our medical community through our hospitals and the business community through the Georgia Chamber and the Metro Atlanta Chamber.
It's obvious the medical community would approve it because they have special protections in here under lines 98 to 107. They don't even have to put up a notice, right?
And no one has to put up the notice. The notice is simply statutory language for those who want to put up the sign. There's no requirement to put the sign up, but no, any ordinary business could put up could operate without the signage if they wanted to, because we define entity or individual, as you see on line 99, back in our definitions, and that makes clear that could be any business operating in Georgia.
Thank you, Mr. Chairman.
Senator Parent.
Thank you, Mr. Chairman. Following up a little bit on Senator Cowser, Whip Kelly, I don't really like that language either, but it's from a little bit of a different perspective on line 127 to 129. And the reason I don't really think it makes sense, but I want your opinion because maybe I'm sort of missing something, is to me, like there's no, of course there's not any liability or death from the inherent risks of contracting COVID-19. Like, to me, that's not even a negligence standard. Like, if that's all the bill did, I would be fine with that. No one should expect that they can go in somewhere because, of course, if you enter the world at all, there's some inherent risk of getting some viral illness. So to me, that's below negligence. Like, that's like, to me, what we've done is make it more than the inherent risks. We are allowing non-inherent risks. We are allowing risks that could, and some would argue should, be prevented to not be able to form the basis of a cause of action. Am I making sense to you? Like, inherent risks, I have no problem with. What's your thought on that?
I think we have a difference of opinion there. I mean, when we talk about, you know, the inherent risk, you know, we know if, you know, as you said, as you go out right now, even when you're trying to do the right thing, there, you know, some people are contracting this, you know, who are trying to act appropriately.
But but that's not the definition of negligence.
The definition of negligence is, you know, the deviation from ordinary care.
Right.
That's certainly negligence. So
well, right, but I took what you just said to essentially be people are trying to do their best. The point of negligence is you're not trying to do your best. And that's why I was asking what the public policy is.
Well,
that would undergird it. I voted yes last year. I totally get it. I just think we're in
remember.
a different place. So
Well, I think that it's still a very real place that we're in right now, and I think, you know, as Dr. Watson said, we're going to continue to have this COVID hanging above us, even though we are getting better at managing it. And so, in my mind, I think we're still in a very real place where this is necessary.
thank you.
Just only follow up on that. It seems to me too that while we are in a different place, there's still shifting science on all this. I mean, there's still different recommendations coming out. And so what is a standard of care today may be different tomorrow based on what you read and what science you get. Obviously, it's better than it was when we passed this last year. But I'm not sure that there's still a lot of things that haven't changed on this. But isn't it true? Yes.
The chair knows what he speaks.
Thanks. Dr. Kirkpatrick.
Yeah, I was just going to sort of follow up on what Dr. Watson said. The variants that are coming out all over the place, we don't really know what impact that's going to have on the process. And so I think the most straightforward thing to do is to just change the date and give us more time to figure out how the variants are going to impact the overall picture with COVID.
Thank you.
Senator Parent.
I don't disagree with that. Of course there are variants. What I'm arguing, or what I'm thinking through, is then I don't think that meets the definition of negligence. So I think we're going way above what the conversation is to a place where public policy would suggest you're not encouraging, but allowing disregard. What you just said would not meet the negligence definition. And so that's kind of what I'm trying to get at. So I agree that there's plenty of science not settled, but then you can't really be negligent when things aren't settled. At least most, you know, I mean, I agree there's slight more risk, but you probably wouldn't win. I mean, like we said, there haven't been any lawsuits. So.
Any other questions for the author? You want to sit tight while other folks come up?
I'll be glad to, Mr. Chairman.
We have Anna Adams with Georgia Hospital Association. Good evening.
Thank you, Mr. Chairman, members of the committee. I come today on behalf of the Georgia Hospital Association and our more than 160 member hospitals in the state. And I'd first like to thank Whip Kelly for bringing this last year and the entire General Assembly for allowing this to move forward. This legislation gave peace of mind to our hospitals and our healthcare providers as we did, you know, provide services that were outside of what we normally do. We had parking lot emergency departments. We're doing drive-through vaccine clinics, and all these things are still happening. And so, you know, I would encourage people to consider some of those business signage questions as maybe it's a reminder to wear your mask. And we are, you know, very much in a different spot than we were a year ago in that we have a better understanding of how COVID works, but it is still very much a threat. And so we would request your favorable consideration in extending this sunset for an additional year in hopes that next year we will not have to extend it again. But it does give us that flexibility to be able to respond to the ever-changing needs and landscape of COVID. So thank you so much for your support last year, and we hope to get it again this year.
Thank you very much. Any questions for Ms. Adams? All right, thank you.
Thank you.
There's no one else that's signed up to be heard on the bill. Anybody else that wants to be heard? Any last words?
Just appreciate the committee's attention and time and thorough debate this afternoon. I would ask for your favorable consideration again.
What's the pleasure of the committee? We have a motion to pass by Senator Hatch. We have a second by Senator Kirkpatrick. Any discussion? Senator Cowser.
I'd like to propose an amendment. You just tell me when's the appropriate time.
Let's do it now.
Okay. What I'd like to propose is to strike the words gross negligence on line 109 and on line 120.
Here's the challenge we have is the bill is actually, I know when you said that, I don't know how you can, well, you could still do it on here. It's just be a little bit more complicated, isn't it?
Yeah, I guess I've got to figure out how you would you're changing the underlying bill, and I don't know that the line numbers, now that it's in statute, I'd have to word it differently. I'd have to say it now is a code section title 51-16-3 would amend that subsection A to remove the words gross negligence, and under A1 the warning text to remove gross negligence.
I think the way you do it is similar to how he did his bill in reference in a section of the code.
It's 51-16-3. My reason is that while you're wordsmithing that for me, Mr. Chairman, if you can find the place to say it, gross negligence is just the absence of slight care. When this started a year ago, nobody would have considered it grossly negligent to insist that any visitor in your store or your premises wear a mask and stay 6 feet apart and wash their hands every 30 minutes or whatever. It's evolving. Now, that's probably absence of slight care, because we all know you need to wash your hands, you need to stay socially distanced, you need to wear a mask. Failure to do that is I think would very easily be found to be gross negligence. And these things will continue to change. I think gross negligence where somebody's just, totally careless. By taking that out, you still cover willful and wanton misconduct, or reckless infliction of harm, or intentional infliction of harm. Those are the type of things we should hold a business to, those standards, not, clearly we've taken out ordinary negligence. I think we ought to take out gross negligence as well, because it's such a moving target, especially as the science changes. And it also makes it consistent with the promise of these warnings, where you're telling people there is no liability, when in reality there is liability for pretty much everything other than ordinary negligence as it is worded now.
Let's do this first. You go back on the underlying bill 359 and tell us the lines you're referencing.
Okay.
I'm going to ask Ledge Counsel to give his thoughts on how you would accomplish that.
It's line 109. The third and fourth words of that sentence, except for gross negligence, just remove gross negligence, so it would read except for willful and wanton misconduct, reckless and continue. And the same thing on line 120, where it says except for gross negligence, just remove the words gross negligence, so it would read except for willful and wanton misconduct, reckless infliction, etc. For the non-lawyers, willful and wanton misconduct is conduct that evidences a conscious disregard for the safety of others. That's the sort of legal framework for that. And so, if a business is showing a conscious disregard for the safety of their patrons, or, recklessly running their business, that's the type of thing, we ought to hold them accountable for. But in this type of liability, that we're really first place in the law we've ever tried to establish liability for somebody contracting a communicable disease in public. I mean, that is a known risk that we assume. We're now creating a cause of action against businesses if they are, reckless or willful and wanton, in my opinion. But we're also now creating it for gross negligence. I'd like to remove that. So those are the two places. It's under 51-16-3A and A1 in the text of the warning.
Let me have Julius comment on whether or not we could make that amendment work and what he suggests on it.
Yes, it's possible to make those adjustments. I understand exactly if the committee approves it, I understand exactly what you are trying to do. In current code section 51-16-3, I guess if the committee would just give me the leeway to add the non-substantive structural elements into the bill to make that occur, that's other than that, it's very much capable of being done.
Okay, thank you. Does anybody on the committee not understand the intent of the amendment?
Mr. Chairman, I just caught one other place to give equal treatment to the medical community. Lines 136 on the original bill also remove gross negligence. That's under Title 51-16-4A.
Okay. So just, at this point, let's go into discussion on the amendment. Was there a second for the amendment? Let's do that first. Second from Senator Kennedy. On discussion on the amendment, my concern with that is while I agree it's difficult to consider the line between negligence and gross negligence, it seems like that move would completely eliminate any responsibilities for businesses to take any precautions outside of willful or wanton misconduct. So then I don't know if a business would have any incentive to offer sanitizer or masks to patrons or to distance people. And I think that does, in my mind, affect people who work at businesses as well. While it doesn't affect workers' comp claims, as we talked about, but the idea of complete elimination, it was something I was opposed to last year, and we had a discussion in the Senate. But that's my fear on it.
Yeah, I'm thinking willful and wanton just means, I know what it means is a conscious disregard for the safety of others. So there's still a standard there they're held to.
Any other discussion on the amendment? And I'll ask the author, do you have any comment on it?
I appreciate your comments, Mr. Chair. I think this is a delicate balance we're trying to strike here in terms of the public health of the citizens of Georgia and the needs of business to be able to be open. And I feel we accomplished that last year. I still feel confident in that. I think we've seen that this has worked. And I think that's why you have all major business groups supporting this initiative. And so I would ask the committee to not accept the amendment.
Thank you. Any other discussion from the committee? All right, we have Senator Kirkpatrick.
I'm just confused about what the amendment is.
Senator Kauser, do you want to address Senator Kirkpatrick on the amendment?
It addresses what conduct a business or healthcare provider may be held liable for if anybody contracts COVID-19 and has injuries or death from it. And the current bill only excuses ordinary negligence. And with my amendment, it would also excuse gross negligence, which is the absence of slight care. It would leave intact that businesses and healthcare providers could be responsible for willful and wanton conduct, which is a conscious disregard for the safety of other people.
I understand the principle, Mr. Chair. I understand the principle. I'm just trying to figure out the process of how it works when it's not in the actual bill that we're...
The amendment will make it apply to the actual statute. Julius can word that and kick it into the exact place where it would be.
Senator Rett?
I'm just concerned that will these amendments gut negligence altogether, or?
I think the amendment, yes. I mean, the amendment does take away negligence claims all the way around.
It eliminates a claim for negligence for somebody contracting COVID on your premises or in your medical facility. I mean, you got to recognize under Georgia law up until today, we have never created a statutory right of action against anybody for not protecting people from catching the flu or a cold or any kind of disease on their premises. That we are, by this statute, the stated purpose of protecting businesses, we are creating a cause of action against them. And I want, if we're going to have a cause of action against them, let's make sure it's bad conduct, not just carelessness. Because humans assume the risk of injury from an illness anytime they go outside of their home and interact with other human beings.
I just want to follow up. I understand your intent, but the way the bill was for the last year, it kind of worked. But if we're going to do some tinkering to it, I think we might need to.
Well, we don't know if it worked. You get 2 years from the date of an injury to file a lawsuit, and our courts told that 2-year period during this judicial emergency, which ended yesterday. So there are 2 years from today for anybody that contracted COVID or died from COVID to file a lawsuit, and we will be seeing them. I mean, there was an article in the Wall Street Journal within the last 2 weeks about to get prepared for the tsunami of lawsuits coming from COVID-19 liability. And I would like for us not to create a greater likelihood of such lawsuits, which I think this statute has done. I think it's done it more so than not having any law in place. And now we're all knowing that this is going to end, we hope it is, but by this own extension of the sunset for a year, the period of exposure will be another, we're extending it for another year.
Do you want to be heard?
I would just say, to answer Senator Rhett's question, I think the concern of, eliminating gross negligence, it could potentially open the door for some businesses not to try and do what we've seen so many do now, which is try and be, good stewards in the community, by encouraging masks and the policies and procedures we have in place here, and that's a very real concern. And if we do have concern about continuing us going down the path of improving the health of Georgians and getting us through the increased transmissions, this would certainly take us a step back. This amendment would certainly take us a step back in terms of the importance we've placed on reducing the transmissions of Georgia COVID cases.
Anybody else want to be heard on the amendment? Everybody clear on what the amendment is? Okay. We have a motion and a second on the amendment. All those in favor of the amendment, please raise your hand. 1, 2, 3, 4. All those opposed? 1, 2, 3, 4. Chair will vote no. Be a tie. The amendment fails. Any other amendments? All right, now we're back to the underlying bill. Do we have a motion and a second on the bill? I believe we did. Now I'm trying to remember. Okay. All those in favor of the motion, please raise your hand. 1, 2, 3, 4, 5. All those opposed? Let me go back. All those in favor, raise your hand. 1, 2, 3, 4 in favor. All those opposed? 1, 2 opposed. The motion carries. It's been a long day. I'm glad it's the last bill. All right. And who's going to carry this in the Senate? Okay. I think I still will. All right. That's all the business we have today before the committee. We are adjourned.
Thank you.